facing the police every single day.
Going to state 5 points that I want to elaborate on during this oral argument. First, this case is really it's about shifting the boundaries of First Amendment speech. The boundaries are set as to what is allowable and what is not allowable. The courts have set that boundaries in many types of situations and many types of cases. In this case, Mr. Levin, the city is attempting to narrow those boundaries to eliminate a substantial amount of First Amendment speech as it's related to an open public forum. Just a quick recap is that a open public forum, such as we're dealing with in this case, has actually the highest level of constitutional protection. The court said public streets and sidewalks are traditional forums for speech on matters of public concern. Therefore, as the court acknowledged, they hold a special position in terms of First Amendment protection. And that's the case of McCullen versus Coakley, which is cited in the briefs. But here we're talking about the very highest level of speech, which is political protest, the use of signs in a public, undisputed, open forum. Not looking at any kind of limited forum, not looking at a partial limited forum, looking at open forum and the highest level of speech. So in this type of scenario, the boundaries, the courts have set the boundaries as in order to continue the private to public discourse, have set the boundaries as wide as possible. What the Punta Gorda ordinance attempts to do is to change those borders to increase the amount of speech that is unprotected by the First Amendment and narrow the borders of speech that is protected. And in doing that, the citation and the authority that the city looks at is essentially the case of Pacifica versus FCC, Federal Communications Commission. And in that particular case, as I will go
the George Carlin case, right?
That's it. I'll be going in that case in detail, but the Pacifica holding and all the holdings that are spin off and discuss Pacifica say, look, this is a very narrow holding. It's limited to the broadcast spectrum. There are reasons to keep it narrower, and I'll get into that. In a nutshell, what the city's trying to do is trying to import FCC, which is a limited, very limited, it's not even a forum, but a very limited spectrum into the public forum and cut off a substantial amount of protected speech. Typically, in order to justify, I think it's acknowledged by everyone that this is a case of content regulation. The ordinance says things you can't say on the sign. It tries to tell people what they can say and what they can't say, or how they can express it or how they can't express it. So this is a content-based regulation. Now, this can only stand a content-based regulation, and Mr. Levin has acknowledged that in his proposed order, but a content-based regulation can only stand if the city proves, we do not have the burden of proof, the city proves that the restriction furthers a compelling interest and that is narrowly tailored to achieve that interest. And the reason what court reporter wasn't ordered or needed is because the record is complete. Everything that's there is going to be there. And it's the city's burden to produce anything that wasn't there because they have the burden of proof. Not that I'm saying there's anything missing, but there could be. But it's the city's burden of proof to complete that record. So what the city has done, instead of demonstrated and showing that there was a compelling interest, the compelling interest was narrowly tailored, simply says, look to Pacifica. You say that the Supreme Court has approved a definition that we used in our ordinance, and that definition came from Pacifica. So it simply attempt to bootstrap the definition in Pacifica instead of actually doing what it's required to do, and that show a compelling interest. It's narrow tailored. And I'll be demonstrating the court how that is not going to fly. It's not going to work. It's not available as an option. We'll also be getting into the clear and express well-known case of Cohen versus California. It's dead on point. It's broad and it's explanatory as any case that I think what anyone would hope to find in the First Amendment jurisprudence. There's no wiggle worm. And I'll be going into that case as a sole, if that's all we had to argue, we should win on that case. But there's a lot more. I think the court and the record needs a complete understanding of what's actually happening here, not just to talk about one case, which should be dispositive on its own. Also going to present the fact that minors themselves have constitutional rights. Minors don't come into this scenario unprotected by the Constitution. And exactly, if minors have a constitutional right to use and say the F word in certain contexts, I'm not talking about home. Home, they have, parents have a right to tell them to be quiet and use the language. But if minors have a right to use that F word in the public forum, then it goes like this. Any attempt to penalize adults for the possibility of exposing minors to words they have a constitutional right to use would not only violate clearly the right of adults, but it would also violate the rights of minors. And again, the home scenario is different, and the school scenarios where we will be pointing out. But our clients were not in that situation. Totally open public forum, not in a school where in loco parentis applies, and certainly not in a home or close to a home, which these things can be. In a home, the boundaries can be broadened, can be changed, but this is not inside a home. We'll be pointing that out. And finally, I want to make it clear if there were any sentiments, this hadn't been brought up too much, but the fact that this is a civil code violation is actually more burdensome and more onerous on free speech as if it was a criminal charge. The code court, people go there, they're rarely represented by attorneys, so taking free speech and suppressing it and relegating it to a code enforcement process tend to keep it from coming to the surface. The members on the code board are actually just appointed by council members and subject to be hired and fired. They're untrained. They can't put things in context, as like the Federal Communications Commission in Pacifica. In fact, one of the code members in this particular, that's not on the record. But it's also at that level, a person cannot raise their constitutional rights as a valid defense. Cannot. So in order to get to the first instance of this case requires your honor and an appeal. It requires being able to locate an attorney that's willing to take it, pay a filing fee. So there's an automatic penalty. In a criminal case, hey, the proponent would have the benefit of a presumption, beyond a reasonable doubt. It'd have a lot of actually better protections. The appeal process in this case is very onerous. It's not streamlined. It's not set up online. We had to jump through many, many hoops just to get to this court. Why is that? I don't know. You know, I pity poor code people who have to get code violated. And also the fines are very onerous. They can be up to $5,000 per day. In this particular case, one of them, the code board just kept fining them and fining them and fining them because they didn't pay. So these fines can be very, very steep. So the point I'm making here is the fact that this is not a criminal case makes no difference. If speech is powerful, if the right to free speech is powerful, if the First Amendments mean anything at all, it doesn't matter how speech is suppressed, whether it's a civil code and a civil fine or a criminal charge, it's equally, if not more important in a case like this. So, you know, those will be the key points I'm making, and those need to be gone into with quite a bit of detail. First, the actual ordinance. I want the court to get a indication, a sense of how broad this ordinance is. It covers I'm going to skip over a lot because 50 minutes may not be enough, but a lot of this doesn't need to be said anyway. The covers in chapter 26, it says, any sign which contains obscene language. Okay, we don't have any problem with that. Obscene language, the state can regulate that all day long, and also minor related obscene language. Or graphics, or any sign containing fighting words. Now, other than this is kind of vague and hard to decipher, fighting words are not protected by the Constitution. Or indecent speech. Now, the indecent speech is where the definition is dragged up and bootstrapped in from Pacifica. Indecent speech is outside of this boundary. The boundary says you can prohibit, legislate against obscenity and fighting words, incitement, but the boundary doesn't go as far as indecent speech. So if the city says, hey, we're going to say you can't have a sign that has obscenity, that's no problem, because obscenity is not within the reach of the First Amendment. Now, indecent words like the F word that was used here and all that is language that's considered indecent. It's clearly protected speech. I don't think Mr. Levin could say that that's not protected speech as to adults in an open forum. It's protected speech. And, although in words, everybody doesn't want to hear the same words. Speech is not just a word. It's also the way it's delivered. It's the emotion. It's the impact. Why has the Supreme Court allowed flag burning as an expression protected against a constitutional amendment? A congressional ordinance upheld flag burning, cross burning, upheld that. It's not just the words of speech. You can't compel out of the mouth saying, look, I hate Punta Gorda. Please, this ordinance is not constitutional. No, my clients are entitled to use that emotive force in order to connect with a particular audience and to show how deeply they feel about it. Courts have upheld signs which saying, God loves dead soldiers, and things much more extreme and much more offensive, things that will offend me. But that's the price of public discourse, that private opinions can be expressed in public open forums. That's how our government works. It's how it's founded, and that's what we're trying to protect. So in that ordinance, Mr. Levin goes on to say, rather the city goes on and defines indecent speech. In Article 11, and I'm not going to go through that definition right now, but it's primarily taken from the Pacifica case, primarily taken from the Pacifica case. Pacifica says patently offensive, otherwise it's pretty much the same. Now, this is important. Now, when the city in its answer brief filed an answer brief, and this is going to help see how broad this statute is and the reach of this ordinance. The city in arguing said this. In fact, I printed it out here especially and highlighted it. It's going to be so hard to see here. But the city said, in responding to this, says the city's prohibition would not prevent the use of signs displaying indecent speech if used at times, at locations, when or where the presence of children under 17 would not reasonably be anticipated. The ordinance said, and this is a different fact altogether, if we had to talk about the fact, says the ordinance says, which in defining the elimination said, which can potentially be viewed by children. Now, what can potentially be viewed by children in the public space, from a public space, children can be anywhere. It has a potential. Children can be there 12 o'clock at night, 1 o'clock at night, 2 o'clock at night, all night. I don't know of any public place where children couldn't possibly be there. Possibly, that's what potentially means. The statute does not say what city says is an answer brief. They say it says the presence of children would not reasonably be anticipated. That's two different things to prove, two different facts. We had no such defense. Is this an effort of Mr. Levin to broaden? Is this say, uh-oh, we messed up, we went too far in this statute, or do we want to broaden it? What exactly is that? Why did they use those obvious broadening terms? Well, I think I would submit, if we look at the wording of Pacifica itself, it says that the concept of indecent is intimately connected with the exposure of children to language that describes in terms patently offensive as measured by contemporary community standards for the broadcast medium. Every word is important. That says for the broadcast medium. City of Punta Gorda is certainly not a broadcast medium. The open forum is not comparable to a broadcast medium. We'll have more to say about that. But it goes on to say, for the broadcast medium, sexual or excretory activities in organs at times of the day when there is a reasonable risk that children may be in the audience. It didn't say whether children may possibly be in the ordinance. If that was the case, that would cover 24 hours a day. Possibly in the audience, it could be up all night. In fact, all the Pacifica cases deal with that. And so, in fact, in applying Pacifica, the FCC doesn't have these restrictions after 10 or after 12 and so forth and so on. The ordinance the city drafted has no time limits, has no geographical limits. It has no way to argue that, well, children aren't reasonably here. It just said, can they potentially be viewed? That's clear, Your Honor. The wording cannot be changed like that without an explanation. Now, that tells us how broad this ordinance is, how it covers every public place in Punta Gorda. and covers what can be seen from a public place in Punta Gorda, not just on the public place, but if you can see it from a public right of way, it's exempted if children potentially are present. Now, in the city makes a proposed order for the court, and it includes this particular finding. And it says, in the context of content-based provisions of municipal sign codes, the U.S. Supreme Court in Reed versus Town of Gilbert, omitting sites, held those provisions can stand only if they survive strict scrutiny, which requires the government to prove that the restriction furthers a compelling interest and is narrowly tailored to achieve that interest. And the proposed order says the court finds that the city has proven both, which is going to be impossible. There's no evidence in this record. There's no case authority in this record which the city can prove both. And if the court thinks otherwise, then it'd be nice to know what that is. But the proposed order doesn't leave the court the discretion to say what it thought it would be if there was any. What we're saying that bootstrap Pacifica, and that's it. And I'll get into more of that. Now, happily, the city cited the case of Reed versus Gilbert. In Reed versus Gilbert, there was a variety of sign ordinances, and they were different sizes and could stay out this long or that long or be here or there, depending on what kinds of signs there were. And the question in that case was, is this content-based? We don't have that question in this case. We know it's content-based. It's clearly content-based. So that, and from Reed, here's what Reed said. In Reed, the Supreme Court did find it was content-based and struck down the ordinance. And here's what some language from Reed case, it helps define the burden of proof and the scope of review in this case. Content-based laws, those which target speech based on its communicative content, are presumptively unconstitutional. Presumptively. So when we come here, look at this ordinance, presume it's unconstitutional. Like it's got to be proven that way by Mr. Levin. I'm going to prove it's not ahead of time, but it's not. And may be justified only if if the government proves they are narrowly tailored to meet a compelling state interest. That's Reed versus Town of Gilbert. Now, in that case, in fact, the court notes it. Well, Reed is not really doesn't think it can survive strict scrutiny. So, there wasn't a whole lot on that because the city had already admitted that, hey, that's our big issue, whether it's content-based. I would challenge anyone to find me a case anywhere that allowed something like this, where you have a content-based restriction in an open forum for First Amendment rights that implicated the highest order of speech. We're not talking about nude dancing. We're talking about political speech, what somebody wants to say and get across. Challenge anybody to find me a case where a content-based regulation was not struck down in that instance. The only thing I could find is Yulee, State of Florida versus Williams, Yulee, where a content-based regulation was upheld. That's in that case presented a very, very unique interest regarding whether judges can ask for personal contributions when running for office, or potential judges.
And the dissent in that case, I think, was Scalia, and he wasn't happy. Or I'm trying to remember who it was exactly, but whoever the dissent was felt like it was wrongly decided very strongly.
Yeah, they could have been. It's hard enough sometimes to keep up with the main opinion.
When I used to do appellate work, somebody once said, you know what that is, Mr. Gentile? That's the dissent. That's not the law. So, but I do remember that it was a pretty, and I may be wrong about who wrote it, but it was, they thought that judge should be able to ask for money, and there was, it didn't fit the legal test. Well,
that could be, that would even be stronger for my case. But, now that the court know that's kind of interesting, if you look at the proposed order when Mr. Levin goes on and on and on and on about Cohen, which is clearly on point, he cites the dissent. Let me remind him, the dissent's not law.
I know you don't have to remind him or I of that.
But you gave me an opening, Your Honor. I'm sorry.
I did.
But in the Reed versus Tyler Gilbert, the majority opinion says, look, assuming arguendo that the city could show a compelling interest, and they weren't saying they could, this case has got to fall, but because it's hopelessly under-inclusive. Under-inclusiveness is a hallmark criteria examination for to see whether strict scrutiny has been met. In fact, the language quoted, and there's a reason for that. He says, the case it's cited says, in light of the under-inclusiveness, the town has not met its burden to prove the sign code is narrowly tailored to further a compelling government interest. And here the Reed cites another opinion. It says, a law cannot be regarded as protecting an interest to the highest order and thus justify the restriction of truthful speech when it leaves appreciable damage to supposedly vital interests unprohibited. In other words, if there's a compelling interest, you just can't leave things undone. You've got to cover all of your bases. You're serious about removing the F word from the public discourse. How would this sign ordinance do it? I submit it's hopelessly under-inclusive. Let me give you an example, Your Honor. Suppose people are protesting in the public forum. They have a sign. It has the F word, and it mentions F some thing, and they're protesting. It's 10 o'clock in the morning. No kids around. They happen to see a bunch of kids being on a field trip. Maybe they're near the courthouse. The kids come. They say, oh, we don't want these kids to see the signs. So they put the signs down. And kids come up and start annoying them. Let me see the sign. And then the better valor leaves these protesters, and they say, F off, kid. Get the blank out of here. Guess what? They could be penalized for the sign that the kids wouldn't see, but they couldn't be penalized for the words that come out of their mouth. Hopelessly under-inclusive. How does a city actually plan on accomplishing this goal with just signs if they can't take the F word out of people's mouths on the street? One of the code members, and I'm thinking this is in the record, one of the code board members said, oh, it's okay to use it on the golf course. It's okay to use it here, but this is different. Well,
yeah, I saw that.
Yeah. So I think if the city did try to do that and eliminate it, God bless them, they would run into Spears versus state. Now, Spears, there used to be an actual ordinance, a state statute that said it provided any person who shall publicly use or utter any indecent or obscene language shall be guilty of a misdemeanor. Indecent or obscene. Obscene was fine, but indecent moved those borders into what's protected speech, just like the city's trying to do. The court struck down the ordinance and said they could not do that. And here's what the court said in Spears. Well, interestingly, the person that was cited in Spears, it's hidden in a footnote. What they said was son of a bitch, bastard, MF, which I think is shorthand for something else. And that's what they said. So in Spears, it says any person, it goes on to say, in the present case, the standard indecent or obscene does not meet constitutional requirements because it doesn't succeed in articulating a boundary between expression which is protected and the expression which is not. There's our boundary. Didn't articulate the boundary. Obscenity wasn't protected. Obscenity, you can get rid of obscenity all day long. So the boundary between what's protected and what's not protected took place right there at one little word, and that's indecent. And that's the same word in the ordinance, indecent. So it didn't protect the boundary. It went into indecent speech. That's exactly the same thing that's happening here. Interestingly, the case went on to explain why, and they cited Cohen because of Cohen. So Cohen's not only good U.S. constitutional law, very clear, it is written there right in the annals of Florida jurisprudence as well. So I'm going to move to Cohen, and the point Mr. Levin tries to make is this is a breach of peace case. Well, it might have had, I'll explain what that means, but let me just give a couple of paragraphs of Cohen. I know the court's read it, but it's made very clear in the Cohen case, at the focus of this case, that if the word "fuck the draft" was not protected, then Cohen could be convicted and charged, and it would withstand. If F the draft is not protected, unprotected, if it's on the other side of the border of the free speech doesn't protect it, it's prescribable, then the conviction would stand. Is F the draft on which side of the border can it be on by virtue of the Constitution and the free speech First Amendment? The court goes on and on and on and tries its very darndest to point out the fact that this is the words and constitutional right to use those words is what's in view. Court says state certainly lacks power to punish Cohen for the underlying content of the message the inscription conveyed, at least so long there's no showing of an intent to incite disobedience or to disrupt the draft. Cohen could not, consistent with the First and 14th Amendment, be punished for asserting the evident position of inutility or immorality of the draft that the jacket reflected. Now, the reference to inciting is at the border direct incitement, forget the name of the case, Chaplinsky or something, but nothing like that was involved here. And it goes on to say, while this court has recognized that government may properly act in many situations to prohibit intrusion into the privacy of the home. Now, this is really important here, what Cohen says about the privacy of the home. Because the court right here is drawing the distinction with Pacifica. Pacifica is all about the privacy of the home. So this language in Cohen, it's already basically anticipated perhaps the broadcast spectrum can be very, very different. But our case is not the broadcast spectrum. Ours is open forum. Now, to be clear, also, if one of my clients had painted this Punta Gorda for violating free speech on their back and walked around with it, that would be a sign. That would be a sign under the definition. It included what's on clothes. So this ordinance of the city is a direct challenge to Cohen, a direct challenge. I think they would say, Your Honor, reverse it, and let's start over without it. But I don't think the court has authority to reverse a clear Supreme Court decision. So, Your Honor, I think also to clear this up, sometimes we miss the footnotes in this case. So if you look at footnote 5 in Cohen, talking about an amicus brief, it says the amicus urged with some force that this issue is not properly before us, since the statute as construed punishes only conduct that might cause others to react violently. However, because the opinion below, talking about the appellate opinion in the state of California, as we remember in Cohen, I guess I'm getting a little bit ahead of myself, thinking everybody knows the facts. I know you do, Your Honor. But this man, 22-year-old, it was back in the Vietnam era, he painted a sign on his back, said, "Fuck the draft." He walked into the courthouse, took off his jacket before he went to the courtroom, sat down, and I think he was there to testify for somebody. And then he took his jacket and put it back on when he left the courthouse. Now, there were women and children who were present in that courthouse. The opinion makes that clear. Women and children were present. Women and children had the potential to see this sign and could, even if you go with Mr. Levitt's term, reasonably be expected to be there. And so getting back to my footnote, that it says here that the opinion below, this case went to an appellate court in California, which upheld a conviction and construed the statute, construed it in their opinion. Now, cert was requested to the Supreme Court of California and denied by something like 4 to 5, something like that. And so then the appeal was directly to the U.S. Supreme Court to clarify what this footnote means. It says the court below, the court that construed this statute, it appears to, in effect, erect a virtual, irrebuttable presumption that the use of the word would produce the results. The statute, as thus construed, appears to impose, in effect, a flat ban on the utterance of this word. And that's what that decision was, a flat ban. And that's what this ordinance has done, a flat ban. The record is clear. When I was actually the attorney at the code board, and the proof was, and I asked all the people there, the members, the code enforcers, I say, there's something in the statute define, rather the way the definition is in the article. And let me back up just a little bit. In the definition, it says Punta Gorda defines the term indecent speech as language or graphics that depict or describe sexual or excretory activities or organs in a manner that is offensive as measured by the contemporary community standard. While it doesn't include the F word exactly, reading it to me, trying to represent them, I said, well, just the F word it wasn't being used like that. Using it F Punta Gorda for destroying free speech doesn't give rise to any type of sexual innuendo. After all, people say F off, what the F, it's used as a punctuation mark all the time. And the code people say, well, it doesn't matter because the dictionary definition says it has something to do with sexual intercourse. And context doesn't matter. The F word is out, out, out. So Punta Gorda has written the F word out with this ordinance as the way it's applied in this case as a pure element of protest. It would have been written off Mr. Cohen's jacket as well by this ordinance and the application in this case. But getting back to the belabored footnote, it says that basically the court created an irrebuttable presumption that if the draft would produce disorderly conduct. Now the statute reads, the first line of it, where that Cohen was prosecuted under, says every person who maliciously and willfully disturbs the peace or quiet in any neighborhood or person by loud or unusual noise or by tumultuous or offensive conduct. Offensive conduct. So what the court did and what this footnote is saying, and the statute's under footnote 1, what this court is saying, well, basically the courts below rewrote this statute, and you could take out the words offensive conduct and substitute it with F the draft. They made an irrebuttable presumption that F the draft violated this conduct. Therefore, the entire focus of the Supreme Court was on this term, F the draft. Just as if they had a statute with it written in there. They might as well have. In fact, it's more onerous to have it written in there because we have this chilling effect. So Cohen, I do not believe that it can be argued not to be applied in this case with a straight face, and it just belies credulity to even suggest that it leaves room open for change in this particular case. I don't doubt Mr. Levin of the city's good faith in pursuing this, but with all due respect for everybody, that argument just cannot stand. And the court went on. I think it's important. I don't want to belabor Cohen, but they went on to point out is what I was talking about. It talks about privacy, okay, and those borders. It's not only it's different. The reach of the First Amendment is different. You know, it'd be different on federal public property. It would be different on private property, and it's certainly different in the privacy of one's home. Cohen made that clear. He says, listen, it says, while this court has recognized government may properly act in situations to prohibit intrusion in the privacy of the home of unwelcome views and ideas that cannot be totally banned from the public dialogue, we have at the same time consistently stressed that we are often captives outside the sanctuary of our homes and subject to objectionable speech. The ability of government consonant with the Constitution to shut off discourse, solely protect others from hearing it. In other words, dependent upon a showing of substantial privacy interest. In other words, I say, look, if you're going to cut off discourse, if you're not going to allow the F word, you can do it, but it has to be focused on a substantial privacy interest. Can't do it in a public forum. So it's certainly not understandable that Pacifica allows that indecency, allows that boundary to be different than it is in an open forum, as it is in this case. So that takes us to the Pacifica case, and the Pacifica is in the answer brief. the city says, and it's what I'm trying to get across, that their reason, we said, accordingly, the city sign code is not unconstitutional because it extends the definition of obscenity. It extends the definition of obscenity. The sign code, because it extends the definition of obscenity, it says the sign code is constitutional because the definition of indecent speech is consistent with terminology approved by the Supreme Court. Now that's reference to Pacifica. Supreme Court in no way, no how, in no fashion approved an indecency definition that could be transported, bootstrapped into the public forum. But that's the entire argument. That's the entire interest that Punta Gorda has shown, has tried to show. The answer brief goes on to say, similar to the FCC regulations held to be constitutional in Pacifica, the provisions in the city sign code relating to indecent speech are content-based. So they're admitting right there, theirs is content-based. Also similar to FCC's actions in Pacifica, the city regulations were enacted pursuant to a compelling governmental interest in protection of children. So that what city is trying to do is to all of the burden that's placed upon the city to justify the ordinance consistent with the First Amendment, focus on Pacifica. Nowhere else is transported. They're assuming that the Pacifica compelling interest, as they argue in the broadcast spectrum, is transportable to the public forum, and it's just not. And I'm going to go into Pacifica into some depth because that's what it is. Let's take this definition of Pacifica, let's write it in the code, but it can't do. That's the borders cannot be shifted like that. Based on a case, it is limited to a certain broadcast spectrum. So actually the Pacifica case, yeah, it was the George Carlin monologue. They were discussing contemporary attitudes toward language, and the Pacifica was not a public broadcasting, but a public interest broadcasting station. And in the course of this 2 p.m. discussion, they played George Carlin's 7 Dirty Words. It's pretty dirty. It's a lot dirtier than anything in this case. And there wasn't much said about it. It's a one-person complaint. And that one person's complaint ended up with the FCC. And the FCC took that complaint and wrote up a declaratory memorandum and opinion. There wasn't a regulation. That's not what happened. There was no regulation struck down. It was a declaratory opinion and order, similar to, I guess somewhat formatted like the one I provided under the Saving Private Ryan. And so, not that makes that great deal of a difference, but it might in some context. So here we have this declaratory order. And it gets quite complex where the FCC, and we got to understand that the broadcast spectrum is really different than an open forum. The broadcast media, in fact, nobody can enter it. No party can enter it. No broadcaster can enter it unless they have a license from the FCC. Can't even, if this was like the public forum, you'd have to have a license from Punta Gorda just to stand up and say anything. So, and under this license provision, very detailed, complicated act, the Communications Act, which empowers the FCC and maybe even created them. The FCC is a very independent organization. It's got the members are appointed by presidents and confirmed by the Senate, the 5 committee. Anyway, it's very complicated.
So let me ask you. Yes. So you're 50 minutes in. How much longer do you have, you think?
Just 15?
You are 50 minutes in. How much more do you need?
I need 50 more.
So, Mr. Levin, rather than him stopping, you doing 10 minutes and starting the whole process. All right, folks, so have we got everybody we need back? I see Mr. Levin. Are you there?
Yes, Your Honor.
Speaker. I'm here, Your Honor.
Your Honor.
There you go. Now I can hear you. Sorry, I turned everything on, but not the speaker. All right, you ready to proceed?
Yes, Your Honor.
All right. And in broadest terms, and this isn't an order or a ruling yet, but I would expect, Mr. Handel, you would all but maybe finish today in the next hour, and then we would start on Thursday morning with Mr. Levin, and then you would have some time to respond, and I would probably give him some time to respond.
Thank you, Your Honor.
Do you think that'll work for everybody if we start at 9 and have a couple hours?
Oh, yes, easy.
Yes, Your Honor.
All right.
Yes.
Please proceed.
Okay. When we were talking about Pacifica before the break, the point I was making is this broadcast spectrum is almost like a public trust for the people. There's only so much bandwidth that can go around. And if all these speakers jumped on it and tried to use it, then it would be worthless for nobody. So it has to have this special protection, special authority over it. And that's the reason why the FCC sets up its authority over the broadcast spectrum. But Pacifica is quite clear in limiting the decision and the reach, the definition of indecent, limiting it to the broadcast spectrum. It's kind of like a wrecking ball. You use it in one place, it works, you take it out, and other place, it's destruction. It might work well in the broadcast medium in protecting the home, but in the public square, it's like taking a wrecking ball to free speech. Anything that could be indecent could be prescribed. That's extremely debilitating to free speech. So keep Pacifica caged. And Pacifica said, yes, keep me caged because I'm only about the broadcast spectrum, not transportable. Pacifica says, when the issue is narrowed to the facts of this case, the question is whether the First Amendment denies government any power, whether it denies government any power to restrict the public broadcast of indecent language in any circumstance. That was a narrow question. It reached that question, and it reached it not totally the way the FCC proposed. There was additional argument coming in. So you have to have context in this. You have to have context. But Pacifica goes on to state on page 748, we have long recognized that each medium of expression presents special First Amendment problems. And of all forms of communication, it is broadcasting that has received the most limited First Amendment protection. And it goes on to say, thus, although other speakers cannot be licensed except under laws that carefully define the narrow official discretion, a broadcaster may be deprived of his license and his forum, in his entire forum, if the commission decides that such an action would serve the public interest and convenience and necessity. FCC has very broad powers there. And the case goes on to say, similarly, although the First Amendment protects newspaper publishers from being required to print replies of those they criticize, citing Mammy Harrell, it affords no such protection to broadcasters. To the contrary, broadcasters must be given free time to victims of their criticism. So the Pacific case is going to make special effort to talk about the limitations. We can do something with broadcasters we can't do with newspapers. It's very, very limited in scope. No, it doesn't go on. The opinion goes on and gives the reasons for this. Now, I think the reasons might be important, why the limitations are there, so the court will understand these same reasons aren't in the public forum. The reasons that Pacific was applied don't apply to the public forum. It would take a huge leap to apply it there, but at least if it's going to be applied there, the reasons for that should be carefully considered. And the reasons that Pacifica used, the reasons for these, and I'm going to read some of the reasons that the courts point out. It says, and I think this is, there's several reasons, just trying to paraphrase from what I've read. You have the privacy of the home is one reason. And that's a paramount reason. And in fact, that's stated on page 759. It says, a second difference, not without relevance, is that broadcasting, unlike most other forms of communications, comes directly into the home. The one place where people ordinarily have the right not to be assaulted by uninvited, offensive sights and sounds in the home. That is a right of privacy. And the court, Pacifica Court, actually cited Cohen. So they're validating and helping to draw the line, the boundary line, by citing Cohen. Cohen has a different standard. This is public forum. So it goes on to note, in a footnote, it notes 4 different considerations, and the opinion goes and talks about children have access to radios and they are unsupervised. Now, one thing to note about the broadcast spectrum, it's viscerally different than walking through a public forum. Broadcast spectrum is people sitting around, their attention is kind of glued to the TV or whatever. Their attention is focused. So if something comes pouncing through, it comes in direct. It's not like you might sit in the corner of your eye. You can't really avert your eyes like it does in this. And that's when they talk about children are there unsupervised. Radio receivers in the home, a place where privacy interest is entitled to extra deference. Unconsenting adults, adults that don't want to hear it, they just want to watch a TV show, may tune in the station without warning that offensive language is going to come through the broadcast. And there is a scarcity of spectrum space. It's a highly regulated space. It talks about, hey, there's only so much broadcast space to go around, so we have to regulate. Now, these factors, one thing interesting about Cohen, and I think somebody could probably write a law review article on it, Cohen never really discusses and applies compelling interest rationale. In almost every Supreme Court case, First Amendment case, they start out and says, well, what type of scrutiny is it? Is this a rational basis? Is it intermediate scrutiny, or is it strict scrutiny? If it's low-level scrutiny, rational basis, that's all you need to support the law. It's not arbitrary and capricious. Intermediate scrutiny requires an important interest, and close tailoring. Strict scrutiny is what we're talking about in this case, is the highest level of examination of a regulation to see how it infringes on free speech. So just to get to the threshold of justifying an ordinance like this, it's content-based, a compelling interest must be shown, not just an interest. Maybe there's some interest in keeping kids from seeing an F word on the sign. I mean, if you really think about it and try to flesh through this, there's a lot of things out in public discourse. The younger kids, if they out there, they're not going to read the words. Other kids could be out there with the parents. I mean, they see a sign, they're not going to really be focusing on it. It's got an F word in it. First of all, where's the harm? Is it harm psychologically? Is it, what is the actual harm in that? I mean, is this an effort so we can tell our kids when they grow up, don't be potty mouth? I mean, that's a good thing, but that's not a compelling interest. It has to be a lot stronger than that. So where is the interest? I mean, the Chamber of Commerce doesn't like it. They don't like to see this, but there's other things that the city can do with sign ordinances, and other than direct an ordinance toward content speech. I mean, this is regulation is unbridled. It's not restrained whatsoever. Ordinances and other sign ordinances can be limited to commercial speech, and there's less scrutiny for commercial speech. So there's a lot of things, but this is just a wrecking ball to the First Amendment. For what? So that somebody might, let's say it's an older kid walking through, he's heard it 100 times. He's heard it from the people, in the golf course, may have even heard it from their parents. It's certainly, there's no compelling interest shown. In fact, let's say he sees that and he's with his dad. He's 8 or 10 years old. Well, dad could say, look, son, that word over there, we don't like it. I don't like it. City doesn't even like it. They'd rather you not say it. But, I think what they're doing is they're expressing strong feelings, strong speech. And they get to say that, although we don't like it, they get to say it in order to protect our right to say things, our right to say what we want to say about government, to make our input known in this public forum. I mean, son, actually, after all, the government has they'll even allow flag burning. They'll allow cross burning in certain circumstances. They're allowed to put up signs say God hates fags. All of this has been protected. And so, first of all, neither cognitively, viscerally, are there any studies indicating that perchance someone's going to see the F word on a protest sign is going to create any harm or any damage. But moving along on that, the Pacific case really sets out the difference. And according to the city's jurisprudence, we'll just import the Pacifica definition. It's imported. Well, Pacifica didn't even, had multifactorial reasons for upholding the limitations on free speech. It wasn't simply for children in the home, and all of these. It wasn't a compelling, it never determined specifically there was a compelling interest. And back to that law review article, if somebody read Pacifica, they would not find that strict jurisprudence. It just finally concluded that FCC has this authority. FCC has this authority. So we import this and claim that's our compelling interest. Now, interestingly, but not without significance, is that when the city imported it, so importing Pacifica, the definition changes the borders, pushes the borders back to what can be said, restricts more speech than what ordinarily would be said. So it's moving those borders back. And in the public forum, now, the city actually moved the borders further than Pacifica did, quite a bit further. It's not the same forum. It's a much more open forum. It's much less restricted. It's not applicable. The reasoning is not applicable, and they show no independent compelling interest, but yet the city ordinance is more restrictive than Pacifica. Now, Pacifica, I said earlier when we just opened it, how narrow this definition is, where children, or how broad it is, where children can potentially be present, potentially viewed by children. Pacifica used the language reasonable risk that children will be in the audience. City uses an arcane code board to make these decisions where there's an interface between First Amendment rights and free speech, and they're not even allowed to consider First Amendment. And also, Pacifica requires context. There was a big issue in Pacifica. You know, can the FCC categorically get rid of an F word? And the determination, the language in Pacifica said no. If you read it, it says on page 742, the approach is appropriate for our courts as well as the commission when the regulation of indecency is at stake. For indecency is largely a function of context. It cannot be judged in the abstract. What the city does, the F word, you know, because it has its roots in something sexual, it's categorically not allowed. Now that's, the best way I could demonstrate, Your Honor, is providing you an actual memorandum of opinion of what the FCC does and how it applies specifically. It does not eliminate every F word, clearly does not, or every nude scene. The city does, in the open forum, and the language, some of the language from the Saving Private Ryan, and that's just one of the many public primetime broadcasts that have used that kind of language. I mean, the F word was strewn all out to Saving Private Ryan, and it's been used in other contexts and so forth. And that's had the blessing of the FCC, as that opinion shows. And so I'm not going to go through this opinion in any detail, but these commissioners say we must nevertheless proceed with due respect for the high value of our Constitution places on freedom and choice in what people say. And so they kind of materialized a test for when the F word can be used and when it couldn't. And, you know, if it's repeated a lot, or if it's used in a clear sexual manner, whether or not it has social scientific value. Like, hey, okay, you hear the soldier say at the end of great stress, you get a feel. So all that's saying is it's nothing categorically damaging to children with the F word. It's not going to kill them. If it's going to harm them in any kind of great way, why do they allow it to go into prime time? There's been no compelling interest. It's this F word is somehow going to derange and hurt children of any age. It's simply not there in Pacifica, but it's there, definitely there in Punta Gorda. Where did Punta Gorda come up with that? Well, they came up with it from Pacifica. That's circular reason. Pacifica doesn't allow it. I mean, doesn't go there. So in Pacifica said, look, we're the most limited spectrum, you know, you're the most open. How does that make sense? Really doesn't. So there's 3 points here to state. Is it to fulfill a compelling interest required by strict scrutiny, the city cannot simply import something from Pacifica. Simply import it. Where is the compelling interest demonstrated? Where is it substantiated? And I'll talk a little bit about the Brown case later. Can't bypass compelling interest proof based on that analysis. You can't just say, well, you got a definition approved by the Supreme Court. No, that's not going to allow the bypass of the compelling interest test. And so now, Your Honor, in looking in due regard for, being comprehensive and thorough in jurisprudence, I started looking for cases as open forum cases. Well, if it's limited, well, what have the courts been allowed to restrict when the forum's open? When we're not in the broadcast medium, is there any additional restrictions that can be put relative to minors? I mean, it makes sense there should be, but if so, where is the line drawn? Are there any cases out there? Pacifica is not applicable. It's special to the broadcast spectrum. One good case to look at, well, first of all these cases go back and cite to Ginsburg. See, the older original case where magazines were sold, nudity magazines were sold to a 16-year-old, and the Supreme Court upheld it. And they upheld it on the basis that there is something that can be restricted relative to minors. It goes.
Which case are you talking about?
Ginsburg. Let's see. I got Ginsburg versus New York, 390 U.S. 629, 1968. Ginsburg versus New York. That's not my best case here, but that's so looking at Ginsburg, that's more of an open forum analysis. We have magazines, we don't have a broadcast medium. They upheld the Ginsburg conviction, and they based it on a standard which they devised for, and they call it, it's not obscenity. I mean, just reminding myself that obscenity receives no protection. So anything that's obscene, nobody's going to question that being outlawed. If something's less than obscene, how less than obscene does it have to be to restrict it, to outlaw? How much less than obscene? Where is that border? Where is that boundary? And so the Ginsburg case is actually about, could be considered an open forum type of case in a sense. I have a better one than that. But in all these veterans always cite Ginsburg, but in Ginsburg they say, yes, you're convicted for selling these magazines. They're not obscene, but they're obscene as to minors. There was actually a definition of what obscene to minors was in that case. So the definition of what's obscene to minors in the Ginsburg is what we have in an open forum. Now, why doesn't Mr. Levin and the city import that definition? It's in the open forum. When I go to Pacifica. Now, turning to Exonerate versus the city of Jacksonville, and that's 422 U.S. 205. 422 U.S. 205.
Just pronounce the first party name. I'm looking for these cases. I'm putting tabs.
Okay, this is Erznozik. Erznozik.
Yep, got it.
Yeah, and in Erznozik, what they had there is a nuisance ordinance, and they made it a punishable offense for a drive-in movie theater to exhibit films containing nudity when the screen is visible from a public street. I'm old enough to remember those drive-in theaters. Don't know if the court is. But
it seems like a good time to plead the fifth.
But this case out of Jacksonville, they made it illegal, to show nudie type of R+ rated films there that could be seen from public ways. Now, this ordinance says, hey, you can't, it talks about the public ways. If you can see a sign with the F word, you can get penalized under this city ordinance from a public right-of-way. It's right there in the ordinance. If you're in a public right-of-way and you see somebody putting up a sign on their property, on their yard, that has the F word on it, F Biden or F Trump or whoever F they want to protest, if it can be seen from a public way, even if they're on private property, then penalized under the Punta Gorda ordinance. Now here, if you could see a drive-in theater from a public street or from a sidewalk, anywhere, if you could just see it, it had these on it. So the court struck that down in Zosnick and struck that ordinance down. And here's what the court said. It says, it's well settled that a state or municipality can adopt more stringent controls on communicative materials available to use than on those available to adults. Okay, we don't quibble with that, but where is the border? That's a quibble. It's not Pacifica. It's well settled that a state can adopt more stringent. And they cite Ginsburg because Ginsburg also dealt with kind of an open forum. And it goes on to say, nevertheless, minors are entitled to a significant measure of First Amendment protection, citing some cases, and only relatively narrow, well-defined circumstances may government bar public dissemination of protected materials to them. That's materials protected by the First Amendment. Only in very well-defined and narrow circumstances can they bar these materials from being viewed by minors, and consequently penalizing adults for displaying them. It says, in this case, the ordinance is aimed at prohibiting use from viewing the films. The restriction is broader than permissible. The ordinance is not directed against sexually explicit nudity, nor is it otherwise limited. Rather, it sweepingly forbids display of all films containing any uncovered buttocks or breasts, irrespective of context or pervasiveness. Thus, it would bar a film, given the outlier examples, it would bar a film showing a baby's buttocks or nude war victim or other cultures nude, a newsreel. He says, nor can such a broad restriction on speech be justified by any government interest pertaining to minors. Speech that is neither obscene to use. Okay, here's where the operative word is, that border that is set in case law, public forum case law is. So I'm going to repeat, or Zosnick. Speech that is neither obscene to use, nor subject to some other legitimate prescription cannot be suppressed solely to protect the young from ideas or images that a legislative body thinks is not suitable for them in most circumstances. The values protected by the First Amendment are no less applicable when government seeks to control the flow of information to minors. Now, thus, Jacksonville's ordinance is intended to regulate expression accessible to minors. It is overbroad in its proscription. Now, here we get to exactly what then the question raised. what is obscene to use, the relative obscene to adults. There's a difference. And the line can be moved to that point. What is obscene to use? That's where the line can be put. And they cite Ginsburg in that. And they're in just about every state in this nation, that line is set, and they have what they call Ginsburg statutes, where they define that line, they define what obscene to use is, and base all of their laws on that in order to avoid First Amendment issues. Chapter 847001 of Florida statutes has that definition in it. So if we want to look at a definition on where the line is drawn, it's drawn in Florida statutes. And that comes out of the Erzosnik, the Ginsburg line. What is obscene to use? And Florida statute has it. It's right there. Now, they've got every law in Chapter 847 wants to talk about it, always refers back to that definition. Now, there's a law against teenagers sexting each other, sending text. I guess you don't hear about much lately, but the sexting law goes back to this definition. And anything that doesn't fit this definition can't be eliminated. They can sext all day long, use the F word in certain contexts. The definition, and that was one of the supplemental authorities that I think the court needs to look at. If Mr. Levin in the city wants a definition, there it is. If they want a different definition, it's going to be a mighty big hurdle, a compelling interest, and take the U.S. Supreme Court to change that line, because this is the line the Supreme Court said. The definition in Florida statutes 847.001, harmful to minors means any reproductive, imitation, characterization, description, exhibition, presentation, or representation of whatever kind and form depicting nudity, sexual content, or sexual excitement when it predominantly appeals to the prurient, shameful, or morbid interest. When it, B, is patently offensive to prevailing standards in the adult community as a whole, with respect which is suitable material or conduct for minors. And C, taken as a whole, is without serious social, artistic, political, or scientific value for minors. These requirements are glaringly and obviously omitted from the Punta Gorda ordinance. There's no requirement of an appeal to prurient, shameful, morbid interests. This is where the line has to be drawn. If there's a compelling interest, Florida's already found it. It's right there. It's not in Pacifica, or it's not in, some other thing. Now, let me share this with you, and it's very important. And I talked about the over-inclusiveness earlier, based on the Reed case, where rather the under-inclusiveness, how under-inclusive this was. If you got a compelling interest, you do your darn level best. If it's that interesting to you, you're going to leave a lot unregulated. You're not certainly going to leave the F word, potty mouth, street, speech, hearing a radio with the hard rap limits and lyrics and all of this kind of stuff. You're not going to leave this verbal assault off the table. You got to clean that up too, if you can. If so, your interest is not that compelling. Now, is it? Now, listen, this is what the answer brief says. I mean, here, and why we did this. how broad it is. He says on page 23, unfortunately, there's no reasonably effective method which parents can protect their children from viewing indecent speech displayed on a sign, which is legible from any public right-of-way or within any public space. Accordingly, the city's sign code is narrowly tailored to further legitimate and compelling interests, and thus it satisfies strict scrutiny. You know, that paragraph right there is proof that it doesn't satisfy strict scrutiny. There are a lot of parents out there that simply are not worried about their children seeing a protest sign, whatever on a protest sign, that they're not concerned because maybe they've taught them in the home, say, hey, this is our rights, this is our free speech. You're going to hear this word everywhere. You know, you're going to hear it bandied around on the golf course. You're going to hear it bandied around everywhere. You're going to hear it in the barbershop. You're going to hear it, you know, you especially got to hear it with your friends at high school. If you see it in the city, you know, is not endorsing it. The city's not endorsing it. That's where people get to exercise their free speech. So think of this. Not only under-inclusive is a test for whether a narrow tailor, also over-inclusive. Over-inclusive. And what about the parents who feel that way? Said, look, I'd rather have free speech. I don't want a wrecking ball to the free speech. Let them use the F word on a protest sign. You know, I may get so hot and bothered about something, I may want to use it too. And I may even want my children to use it. I might teach them that way. So how many parents feel that way? I'm sure there are some. Over-inclusive means, okay, well, you included those parents too. You want to protect some parents. So, you know, their kids might not see it. So what about parents that want to be protected? They want to be protected from the restriction. So over-inclusive. An ordinance cannot be over-inclusive. So they include, he says, there's no way which parents can be protected. How many parents want to be protected? A lot of them don't. A lot of them would be out there protesting, using the words that they feel like they can use to get across their point. It includes those parents too. So you got a parent out there protesting with his kid. How are you protecting that? That's over-inclusive. You're not protecting them, you're penalizing them. You're including parents that this doesn't apply to. You're applying it to everybody. And why are you applying it to everybody? You know, really you're applying it to everybody because it doesn't mean your motive's bad. Now there's other ways the city can go about promoting good speech, good language, and so forth. They can do brochures, they can do teaching. The city can have its own viewpoint, you know, but they don't restrict the viewpoint in the way that others express their viewpoint. The city cannot express its viewpoint by taking across, by impairing the freedom of speech. That's no way for the city to express its viewpoint. They can't express the viewpoint through my mouth when I'm in a public forum by saying what I can say and what I can't say or how I say it. They're fine. They can go signs up, all their own signs. Use only good words. Don't say the F word, you know. They can empower parents anyway. Okay, now, clearly, this is, you know, over-inclusive, and there are other things that the city could do. Do they have a sign ordinance that deals with advertising on the street? You know, they could try to narrow something. I'm not sure if it would pass muster, but they could at least give it a shot. Say any commercial advertising posted on a building or it can be seen from the street. They didn't try this. In fact, this was as broad as it could possibly find. It's like a lawyer trying not to miss anything. it's not like trying to protect anything. It's trying not to miss anything, whether it's on the car, whether it's on the clothes, where children could possibly be. It's nothing restrictive about it. Restrictive would say, okay, you know, your commercial establishment, and just limit their focus, commercial signs or in something like that. There's other things that the city can do. So I'm better speed along because time really flies when you're having fun. But minors have constitutional rights too. We've made that point, but we hadn't made it as strongly as I want to make it here. And we know minors have constitutional right. Or Zosnick tells us, Cohen tells us, Tinker, the armband case, protest case tells us.
What's the new cheerleader case?
And that's what I'm going to. That's Mahoney Area School District. And that's 141 Supreme Court 2038. And in that case, the cheerleader.
You don't have to give me the facts. There's no court order, and I read it, so I remember that.
Okay, great. But the gravamen of the case is that does Tinker apply outside of school? And they said it does to a limited extent. Tinker applies, so the school has some regulatory authority, but only so far. And why Tinker applied, and there's another case cited by the appellant where a young guy gave this provocative speech, and it wasn't expressive words, but it was very, very explicit imagination. That was directly in school, and so they allowed that to be outlawed. That speech and other things was directly in school. She was outside. They tried to tie in the cheerleading program with the ability to restrict her speech. And they said, yes, it reaches out there, but just not enough so that your First Amendment rights, I mean, Tinker's all about how much rights do they have versus the school's ability to keep order. They said, yeah, she can say all these F words and so forth, and that is protected. The Supreme Court protected her right to say that. It was based on her right to say. Her right to say that outweighed any need of the school to maintain discipline. And they could have outlawed it if she was in school in loco parentis, but not out of school, because they didn't need that to maintain order. It was too remote, too far outside. So it was decided on her right to utter those words. So yeah, I'm getting to the end here. I'm about to run the time, right? 2:30?
Yes, sir. That's when my next hearing starts.
Yeah, I'm getting to the end of what I have to say. But there is a final issue that we talked about, and that's, and this goes beyond the constitutional issues, but it's all the same facts, because as a matter of law, we have asserted in our briefs, in a matter of law, that to categorically outlaw the F word was error, because in the context that it was used, F Punta Gorda for robbing free speech, F Biden, F Trump, what the category in which it used could not have met the city's definition. And the city's definition, you have it there. City's definition is indecent speech, language or graphics that depict or describe sexual or excretory activity or organs in a manner that is offensive or measured by contemporary community standards. It was our contention that the way the F word was used, it's not used in a sexual manner. And, you know, to use it, I mean, this word has been transmuted and all that, and it's used in so many contexts. And I could not get anybody in the city to even admit if somebody said, what the F, that, you know, wasn't a sexual manner. It's just if you use F, it's going to be sexual categorically. So we're saying, Your Honor, you know, take a look at the definition, and we think no reasonable code force could do that. Mr. Levin says, well, it's a competent set substantial evidence rule. And we don't think it's necessary to get there. This is clearly unconstitutional, but we have to preserve the argument. Mr. Levin says competent substantial evidence rule. And I say there's no need to weigh the evidence here. The only thing that was outlawed is exactly the way it was used on the sign. Just like the court can read a contract and interpret the terms, you know, they don't get the presumption of a jury's meaning of the terms. And just like the court reads the statute, you know, and makes that determination. And to review this matter, it's just the plain words on the sign. So there'd be no need to defer to a trier of fact or apply a competent substantial evidence rule. And so that's our last point would be, hey, if for some reason the court finds this is not constitutional, then, you know, it couldn't have applied in this particular context. Now, there is a whole lot of effort being made. What the city is asking here is, you know, to apply an entire paradigm shift to the role of Punta Gorda, the whole paradigm shift. Punta Gorda, as part of city government in general, the duty to protect constitutional rights is there in open forum. And FCC Pacifica, the duty there of the FCC, they have a narrow broadcast channel, regulate and administer it, essentially channeling what people can say, who can say what, and that type of thing. So in order to bring that type of system into Punta Gorda, they would have to have a regulatory agency that, you know, look at the public forum as if it was a broadcast channel, and it's not benches and stairs and sidewalks and in places where people can interchange and exchange ideas. Yet it's a broadcast channel where broadcasts continually come. So if Punta Gorda says, hey, that's not ours. That's not ours to regulate. That's not ours to decide what's decent and indecent. And, you know, in order to do that, the federal government had to have just a huge independent agency to regulate this. Broadcast channels, scarcity and limited channels and coming into the home. Punta Gorda is not there. Punta Gorda's primary duty is to protect the freedom of speech and the constitutional rights, not to get in a position where it can regulate it and regulatory authority over speech. You know, who wants to live in that kind of world? And I think people that don't get this case, it might be sitting and listening, well, I don't like those F words. That's kind of a good idea. They don't understand the ramifications this could have. So today, the F word is a bad word. Tomorrow, you get jail, you get penalized for misgendering or looking at somebody the wrong way. You know, this whole idea of local government, any government becoming the regulator of the speech instead of the protector and setting appropriate boundaries is scary. That sets us between being communist China and the USA, because out there in the public square, we can say what we want to say and do what those are our ideas, you know, and sometimes those ideas catch hold, not always. The government can always say what they want to say and express their ideas and their viewpoints. But to limit people from being able to express their ideas is destroying the marketplace of ideas and where those ideas come from. And once you start encroaching them, one word, two words, pick this word out, and then apply the rationale for that, government becomes a regulator of speech, not a protector of First Amendment rights. Now, which world do we want to live in? We want to live in the other one? Let's go to China, you know, where they regulate what you say and regulate everything. Public forums have just said, beyond regulation, the marketplace of ideas. Thanks for all the time, Your Honor. I guess that's a good place to stop.
It was my pleasure. I appreciate y'all doing all the work and being ready to go. We've got a different clerk this afternoon than we had this morning, so I'm just going to say for her that appellant's counsel for Mr. Sheets and Mr. Massey, and the cases are 21 CA 1015 and 21